Now, the Durban High Court yesterday heard arguments from the ANC and the uMkhonto weSizwe party legal representatives over the use of the name uMkhonto weSizwe and the logo. The ANC says it is a matter of public interest that any voter confusion caused by the unauthorized use of intellectual property should be clarified before the elections take place. Addressing MK party supporters outside of the Durban High Court, former ANC President Jacob Zuma said the ANC should not cry foul, as it is the governing party that decided to do away with uMkhonto weSizwe. A judgment in this case has been reserved. Now, if you remember, on Tuesday, the MK won the first of the two court battles between the parties when the Electoral Court dismissed the ANC's application to have the MK party deregistered. Joining us to talk a little bit more about intellectual property and what's going on here is Karen Kitchen. She is an intellectual property attorney that will join us here from Breedenkamp Intellectual Attorneys. It's so good to have you, Karen. Thank you very, very much for your time.
Good morning. Thank you for having me on air today.
Absolute pleasure. So give us your views on what's unfolding currently in front of the courts. I mean, the question of ownership of the name uMkhonto weSizwe and some of the concerns that have been raised by the ANC of a potential to confuse ANC voters because of the similarities in these logos.
Yes, I mean, it certainly is a very complex issue. And if I may just give the viewers just some basics in terms of trademark law. So we generally have common law trademark rights, which are established through use over an extensive period of time, for example. And then we have statutory trademark rights when a party secures a trademark with the CIPC on the trademarks registry. So from what I understand in this case, the ANC does not have a registered trademark, but I do understand that they obviously have common law rights in the name uMkhonto weSizwe, as well as their logo, which is the warrior with spear logo, if I may call it that. So there are a number of issues here, and the question is who has the prior rights in both of those trademarks, the word mark or the name and the logo. So we do know that obviously uMkhonto weSizwe historically was a paramilitary wing of the ANC. So it does appear on the face of it, and again, I reserve comment with, the historical first use of the mark, etc. But it does appear that the ANC has what we call prior common law rights. So, I do believe they have sued on the basis of trademark infringement, which would only be allowed if the ANC, or viable rather, if the ANC had a registered trademark, which they do not have. And therein lies some of the complexities involved here.
Yeah. So, I mean, we look at the representatives of the MK. They also said that there's no damage being done, arguing that it is not true that members of the ANC will be confused on the ballot paper. Let's perhaps talk about the trademark elements which are at this point of the argument in case right now.
Yes, so just in terms of pure trademark law, to determine if a trademark is confusingly similar, if one trademark is confusingly similar to another, you generally do a side-by-side comparison and you look at, are the marks visually similar, are they phonetically similar, and are they conceptually similar? On the face of it, and in my opinion, I do believe these are similar trademarks. I mean, they're identical insofar as the word marks are concerned. And we do know that the ANC's use of uMkhonto weSizwe was abbreviated to MK. So therein lies a bit of a problem on a visual comparison of the marks. Phonetically, they sound the same, and then conceptually, they are identical because they have the same meaning when translated into English, which is spear of the nation. So on a pure trademark comparison, we are, in my opinion, comparing confusingly similar trademarks, if not identical. So the critical question is who has the prior rights, and can they evidence those prior rights sufficiently in order to enforce those rights going forwards?
Yeah, obviously they bring up the argument, okay, great, so there's, and this was brought up in court by the lawyer Sekekane, saying that it would be ridiculous to think voters will confuse Ramaphosa's face on the ballot with whoever will be on the MK party vote ballot. So, and this is where they're bringing in the argument. Does that make a difference? I mean, even though if we sort of add the faces of the political leaders and the party representatives onto that with the logo, does that make a difference? Or must we argue this clearly on those logos as they stand right now on their own and what they'd look like on a ballot paper?
Look, I think there is some kind of persuasive value in that argument insofar as the imagery of the respective politicians is concerned. But on a pure trademark comparison, we are dealing with, we've got to compare one trademark with another. And I think there is scope to argue that a reasonable person may get confused and believe there to be some kind of affiliation between the ANC's historical use of the uMkhonto weSizwe trademark and the MK's current use of a identical and or confusingly similar trademark. But again, I just would like to say, there are some complexities here in that arguably there was interrupted use of the uMkhonto weSizwe trademark by the ANC when it disbanded the uMkhonto weSizwe wing back in 1993. So there are definitely complexities in this case, and there has been a curveball that has been introduced with another third party that appears to have a registered trademark, a third party called Legacy Projects that appears to have a registered trademark for, let's call it the logo device, which is the warrior with spear device, which is almost identical to the ANC's logo device, which is the warrior with spear device, where the spear is above the shoulder. Whereas arguably, MK is maybe saying their logo is slightly different in that the spear is above the waist. Are those really massive differences, or in terms of trademark law, we have to just show the marks are confusingly similar. They do not have to be identical. So there are some issues at play here.
So the interesting point in terms of this legacy project, because that is now also brought in that little confusing issue into this now, the third party. But afterwards, we did see the ANC Secretary General, Fikile Mbalula, saying that the legacy project registered the MK name as its trademark and then ceded it over to the ANC. Those are the comments that he was making.
I'm not sure about those facts. So I'm not going to comment on those. But
if in fact they did, does that make a difference? If let's hypothetically speak, if they did actually cede it over to the ANC after trademarking it, would that make a difference for the ANC? Would that be a stronger case for them?
Look, it would depend on the intention of that legacy projects party at the time of filing. At the end of the day, if that is a valid and enforceable registered trademark, and that can be proved, that could add merit for the ANC's case. But similarly, that third party mark may be invalidated by virtue of, at the time of filing, it was not filed by, let's say, the bona fide proprietor and the original conceiver of that mark and that logo.
Yeah. The MK representatives argued that there must be a clear right to ownership, not prima facie evidence, but an outright ground with no shred of doubt. So on the other hand, there is history associated with the ANC's claims. We know that. You outlined that briefly for us. And the party says that it is its legacy. Does the ANC have a point in all of this? I mean, we know this was the armed wing of the ANC, the former president, late Nelson Mandela, heading it, starting it. Does that not sort of work in the ANC's favour as well? Do they have a point there?
Look, I think if the ANC can clearly evidence that they were the original founder of this name and the logo, and they can clearly evidence that, etc., and they can show extensive use and that they have gained goodwill and a repute in this name, and the reasonable man associates that name with the ANC, and they can clearly evidence that. I think they don't, even if there is a slight element of doubt, it's not like criminal law where there has to be an absolute, there has to be beyond a reasonable doubt to prove guilt. That doesn't necessarily apply in terms of trademark law, particularly cases based on passing off. As long as the ANC can show this very clear historical lineage and that they're conceived of and continue to use the mark, and or generally the reasonable man associates it with their party, then that could be sufficient for them to be able to enforce their rights against the MK party.
So if we look at what the MK representatives were arguing, they were saying that the ANC has no locus standi and want proof of ownership and registration of these elements under discussion, that of course being the warrior and a shield. If this is the case, on what basis is the ANC constructing its case if there's no trademark infringement here?
It would be on the basis of its common law rights.
Okay.
So based on my assessment of the trademarks register, it does not appear to me that the ANC has a registered trademark right, which would certainly assist them in their case. They now have the burden of proof lies on them to establish and prove the common law rights that I've already spoken about.
All right, interesting. So there's also this issue, which is another one of contention, is the issue of jurisdiction, and the Durban High Court is not the right court to be hearing this case. If not, which court is the appropriate one for a case like this?
Look, typically, if there is a registered trademark and statutory trademark rights that are brought into the mix, into the court case as such, typically the Pretoria High Court would be the appropriate court to hear such a matter. Given there's various other issues at play here, I'm not going to comment on the jurisdictional right or wrong, because there are other issues other than the trademark rights that are at play here.
Finally, as we sort of wrap this up, what do you think the prospects for the ANC are in winning this case? We saw that they had a disappointment in the Electoral Court. That was their first blow. What about this one? Do you think they stand a good chance here, even though they have said no matter what, if they do lose, they are going to appeal? That goes without saying.
I do believe that the ANC certainly got a challenge on its hands, particularly with the introduction of now this third party that has a registered trademark and or a prima facie valid and enforceable trademark right that they can assert against both parties, etc. So that needs to be dealt with by the ANC. On the face of it, as a first step, that third party right needs to be potentially invalidated to the extent the ANC needs to invalidate it.
All right.
They also, if they can evidence a clear right that they have established through use since 1961, when this name was conceptualized and the logo was created, I think if they can dig up all that evidence, etc., I think their prospects of success are good.
All right, let's leave it there. Let's see what happens. Of course, that's what we are waiting on as judgments reserved. So we'll keep an update on that one, and it certainly needs to happen quite fast. In the fact that elections are coming up, and all of this is happening in a very, very crucial time for them. Corin Kitchen, thank you. Thanks so much for giving us a better understanding of the whole issue of intellectual property. So Corin is an intellectual property attorney from Breedenkamp Intellectual Attorneys, giving clarity on some of those issues pertaining to intellectual property following the Durban High Court case yesterday between the ANC and the MK party legal representatives over that use of the name uMkhonto weSizwe and the logo.
Very, very interesting.
It is an interesting one, and you sort of wonder, I can't imagine it's also very emotive. There's a lot of emotions that go into that logo as well, uMkhonto weSizwe, and how the ANC feel about it. But then the issue that former President Jacob Zuma was talking about outside of court, saying anyone can own it now. You guys disbanded it, so what, you know, that was what he was saying yesterday. So throwing that in their faces.
It's very interesting listening to Karen, listening to both sets of legal representatives yesterday making their arguments. I found it absolutely fascinating, and I can't wait to see how this one's going to go, because it really is interesting. As Karen pointed out, there are other issues at play as well, but just on the copyright issue, that for me is absolutely fascinating, because as Karen says, unlike, you know, in a criminal trial, the burden of proof, so to speak, seems to be slightly lower, but I can't wait to see how
Neither
this is
can I.
go.
It's going to be an interesting one, and of course with a third party being thrown into the mix, that's also making for interesting times.